Well, welcome. We're going to get started. We're all in the right room. Only you can prevent family fires. For those who do not know me, I'm Phil Stahl. I'm a forensic psychologist who lives in Arizona. To my immediate right is Judge Mark Uhas. He's a Superior Court judge in Los Angeles County. To my far right is my fellow jokester and friend, Mike Kretzmer, an attorney from Los Angeles County.
We had the idea for this workshop, Mark and Phil and I, several months ago, and it's been kind of an ongoing discussion. And the idea, in part, has been how to get out front of many of the problems we see in family law. Because frequently what happens in our profession, no matter whether you're the lawyer, the mental health professional, or otherwise, we come into the problem after the divorce has started or after the controversy oftentimes gets out of hand. And it seems to us that sometimes we're working at the wrong end of the horse. And that maybe what we need to think about is more proactively what we're able to do from our respective professions to help alleviate some of the problems we see before they get started, and also to more effectively deal with them at the very beginning of cases rather than after things have blown up, or after there's been a first appearance in court, or after the custody evaluation or mental health professionals have otherwise been involved with the family. With that idea in mind, we have a series of questions that we might present to you. How many of you are working with clients who are just completely satisfied with the process of family law? What? People unhappy with how long it takes to... How many people run into the problem of people feeling it just takes too long? How many think it's too expensive, too stressfully debilitating?
For them, not us.
How many of you is it too stressfully debilitating for?
We struggled with clients, attorneys, judges, and laws.
Clients, attorneys, judges, and laws. No, I actually think that's pretty good. Thank you.
We stuck with judges as part of the problem in the system.
And in what way?
The joke was, how many judges does it take? No.
Does it take to change the light bulb? Tremendously long delays just to get a date.
And what's a tremendously long time?
4 months to getting an initial court date, potentially. Okay, and then 2 to 3 months to get your motion heard. What kinds of things do you see in the system that are working well, where there's multiple opportunities for trying to reach settlement in advance of trial, either with volunteer attorneys, with professionals who have a good understanding of some of the system, maybe a good understanding of what the judge will likely do, and then even with the judge, him or herself, before a trial. Two-part question that you've all been discussing wonderfully. If you can make changes, what changes would you make anywhere in your family system, and what might be the impediments to those changes? From Ohio.
Is that different than a mental health evaluation, though?
Well,
Or is that just kind of a general divorce education?
yeah, maybe more divorce education.
Okay.
It sounds to me like it's the case. Are you crazy? You want to get divorced? Okay.
Do you know what you're really getting yourself into when you file this paperwork?
Yeah.
The second thing we wanted to see was a visioning exercise akin to some different results.
And who does those things? The visioning exercise, the early neutral evaluation, and the education piece. Who does those?
The education piece we were thinking would be some kind of like a class/video thing that would be put together maybe by the court or something. That
okay.
There would be an education piece that we would have to have our client sign an affidavit saying that they saw it or did it or something prior to filing the divorce. So it would be something called reality check or something like that, so that they've done the education piece.
Sanity check.
They still want
Is there a
to
sanity
divorce in spite of knowing all of these things.
Look, I'm going to jump in and preempt something a little bit that we've been discussing too. Does anybody have a jurisdiction where there's a requirement for some kind of real marriage kind of counseling as a condition to get a marriage license?
Like, here is what you can endure on the back end in terms of this stuff. So this is a very serious step. You need to consider seriously what you're doing as you embark upon marriage.
So can we loop back, though, for just a second? So Save for Children, if people wanted to dissolve their marriage, how do they do that? If the state's going to get out, or the government's going to get out of the divorce business, how do they do that? And the follow-up question in my mind is, many of the laws are designed for economic protection of one spouse or the other. I have a very good friend that was a stay-at-home father, stay-at-home husband. Well, his wife went out and was a breadwinner. And so he was protected by the community property laws in California and whatnot. And so I guess my question is, if you're going to assume that part of caring for a child is financial care and spousal support and properties division and making sure that everybody gets their due, pension plans and all of that, how do you do that if the state's not involved in some way?
What are our assumptions that we often have about parents? Do we think that parents have, is fault an issue here, blame an issue here? Do we act this way? Or do we think this way with our clients for what they come up with? How much should we consider the whole concept of self-determination? So when we talk about mandatory parenting classes, does self-determination come into that idea? Are we respecting parents when we make such orders? Or what about the issues around stress? Are their stress, their children's stress? Those kinds of things. Let's talk about respect. As we went through our thinking about some of these issues, this was a huge issue for us to think about how we think about these parents, about self-determination, about how maybe there's a lot of blame in the system, there's a lot of fault in the system, there's a lot of allegations in the system. What is this all about? What can we do? Yeah, Rebecca. I think that's a great point, and I think it goes back to if we respect them as humans first, before we get into the challenges that their current actions are bringing, that can be a real big plus. Okay, thank you. What else?
So let me add this, and this is the topic, I think, of an entire week's. Where does the state of California have the right, or any government have the right, to tell somebody, an intact couple, I can go home and I can smoke and I can drink and I can do whatever I want to do, but the minute I file for divorce, I, as a judge, am going to say you can't smoke, you can't drink, you can't do other things around your kid.
And you must pay for your child.
I think part of the issue now is, again, respect for them as individuals who chose or didn't choose, but have children. And does the system of divorce create a dynamic where some system is now telling them how to live their lives, that they may not want to live that life, and maybe can't even afford to live their lives. I mean, I said in an earlier workshop today, I went to Tim Hortons this morning for, a pastry and a cup of tea, and you basically see, your everyday working people coming in there. And we tell them they got to send their kid to college because they got divorced, where we may not tell them that if they stay married. That's an incredible thing sometimes.
I do think around this topic of respect, that we need to look at how we view the people that we serve. And, it's routine to make non-disparagement orders. It's routine to make all kinds of orders that the state is involved at a level that we wouldn't be involved in an intact family. And is that reflective of respect, or is that reflective of something else?
Let me hold on just a second, because I know you can raise. But some of the discussion that is being generated with regard to this comes out of one of the articles that I think we included in the materials. There's a fascinating article that was written in the Columbia Journal of Gender Journal, I think is what it is. And Mark may have a copy of it. And
I don't have a hard copy, but I can get it.
We'll be happy to send it out. But it was a lengthy article on sending people to parenting classes. How many jurisdictions do we have where the courts send people to parenting classes. Okay? Now, I ask you,
want
how
your
much
email
literature
here?
have you
Do
seen
you want your email here?
giving us feedback on what the result is of all these people who've gone to parenting classes? What does it do? A lot of the things we do are very thin in terms of the database. I've seen some of Sandler's stuff on that. I can't tell you that in California you get a lot of people saying, oh, yeah, hey, it's great and it's all supported that we send people to parenting classes all the time by the evidence. The other thing, my own other pet peeve is, people argue about the percentage of custody. How much literature is there out there as to what the proper percentage of custody is in any situation and why? It just, really doesn't exist. But on the parenting classes seem to have come about, at least the theory of this article that we'll pull up the name for, in part, and I think it's a very credible theory, because we make an assumption that when people separate, they've done something bad. If they have kids, oh my God, it's going to be devastating to kids. It's going to be bad for the kids. And I think that's just a really faulty assumption to necessarily begin with. People divorce for a whole bunch of different reasons. And sometimes we look at it as fault-based and blame, and gee whiz, they must be defective parents, so we're going to send them off to parenting classes and the whole bit. And maybe what we need to look at is something different in the process, which is, what do parents need to get back up on their feet and get out of the kind of the crash of emotions and the financial crash that comes sometimes with divorce? Yes, ma'am, in the back. You waited very patiently.
Can I just share a pet peeve around respect?
Of course. Sure.
Lawyers who disrespect other lawyers. Do we see that a lot? I know. Well, this is a plug. Go to Rebecca's presentation tomorrow. I mean, that is a huge problem for some of these cases. I sit in on depositions, and I read depositions a lot in my work as critiquing other people's work, etc. And I can't tell you how often I am reading depositions or sitting there at my own or someone else's deposition, and I see incredible rudeness. And I, quite frankly, cannot understand why somebody doesn't turn and just look at their attorney in that moment and say, excuse me, this proceeding's over, you're fired. And it would be nice if parents could do that. It happened in your courtroom. I actually, on the other hand, attorneys who disrespect the court. I've heard a story earlier today about an attorney who continually brought up as an objection something that the judge had made numerous rulings on that objection about whether the expert was qualified. And, again, the client apparently is looking at their attorney like, would you get off of it already? And the court got very frustrated. So disrespect for our peers is, I think, a real potentially serious problem. Judy? The research that's been done by Sandy Braver and a few others on litigant satisfaction is very clear. The single most important thing that litigants want is to be heard. Doesn't matter the outcome as much as it matters to be heard. And I think that throughout the system, people feel not heard by whoever they go to seek out. Good or bad, right or wrong, I've often felt that one of the fundamental tasks of a child custody evaluation, which for those who don't know me is what I do in my day job at times, is really to listen to parents. The end of the day is to help the court. But through the process of it, it is to listen to parents. And one of the reasons I've always felt that is because all too often parents have nobody who is really listening to them. Go into the attorney's office and they're thinking strategy, they're not listening. Go into court, they have 5 minutes and they don't speak, the attorney speaks. Those kinds of things. So litigant satisfaction comes from being heard, comes from being respected. And the more we can fix that from the beginning of the system, the better.
Okay, we have only a few minutes left, and so I certainly want to address any comments or questions that anybody has. The idea behind this was really for us to become educated more so, I think, than you. We come from a relatively, on the west side of the United States for the most part, where we spend most of our practice, where Mark sits as a judge, where Phil does an awful lot of his work. We see a tremendous impact in L.A., which we, again, tend to think of as the center of the world for a variety of reasons, with this huge court system and all of these people flooding in and out of it. But we're looking for ways to make the process better for the litigants. And if we can make it better for the litigants, I think we can make it better for us. And the idea to leave here with and go back to your communities with, and what we'll certainly go back with a number of the ideas that you've expressed today, is how can we help people get through the process? How can we develop a culture that better enables people to get through the process? We began, the three of us, talking about this largely with three ideas in mind. People want to be heard. They want to tell their story so badly. They want somebody to listen. They want somebody to be empathetic. They want to be respected. And I think the third thing is they want to get back to the point where they can live their lives going forward. And we see too often divorces that take far too long, or divorce cases that just devour court resources to the exclusion of maybe the pro person alike. I mean, I've been involved in cases, Mark and I were involved in a case that went on, I think, for some 8 weeks in Mark's courtroom. For, 8 weeks, while there are many other cases that are stacked up and trying to get into courtrooms in an era of dwindling resources, both from a personnel standpoint, from a money standpoint, and the like, it slows and grinds us down. And tell me any divorce situation that you know of that has benefited from being stretched out over time. Okay? That increases the stress level. It increases the likelihood that there's going to be real economic determinations that are going to be very negative for the family. So I think there's really an emphasis on getting something done. What do people want? They want somebody to make a decision. They want somebody to make a decision. And I would submit, daring though it may be, sometimes they don't even want the right decision. Just make a decision so we can get on and move forward with our lives. So what we're looking at is the process of the beginning. How do we somehow come to grips with the fact that the machinery of divorce gets slowed down? Are there things we can do at the beginning? My pet areas are, why not parenting education as a requirement to get out of high school? Why not have some kind of 4-hour course that somebody must take in order to get a marriage license? To say, look, here is the reality of what you're doing. Here is the seriousness of the bond that you are going to create, and here's what it might look at the back end. I even float the idea of getting a renewal every 10 years, and having people go, do that somewhat facetiously. But the idea,
Mike, I've never known you to be facetious, and that's on the recording.
But the idea really is, what can we do, and how can we go into the community and use the resources and skills we have to try and blunt some of the effects we see at the back end when, like I say, we're at the wrong end of the horse or the elephant or whatever animal you choose. So that's where we're coming from. That's what we tried to do in terms of this program today, is to stimulate some talk about those kinds of issues. So if anybody has any comments.
Well, I was just going to, actually, Mark, you want to make a final comment or not? Before?
No, go ahead.
Okay.
This is something that every time I come to one of these conferences, I think, this is such a social body that it used to be, and we've got a lot of work to catch up with that.
It's really, it's fascinating. You talk about that. Some of the research behind the history of divorce, which would make just a great class anyway in terms of law and its development, is the last state to enact a divorce law. Anybody have a guess when it was? No, just the last state to finally have a divorce law on its books.
To permit a divorce?
To permit a divorce, yeah. South Carolina, 1948.
1948.
1948. Okay. There were times in the mid-1800s and beyond when you had to go to the state senator, to the governor, in order to get a divorce. There were things you had to do in order to be able to effectuate that. So 1948, the last state in the Union, comes up with a divorce law. 1972, California came up with no fault. Okay? So a lot of people think no fault changed the landscape. And you're right. We've gone from the tender years doctrine and, I grew up watching divorce court on TV. What greater theater was there than, he was unfaithful or he was a drunk or whatever. We wiped all that out. Okay? Mom used to stay home in an A-frame skirt and heels and mop the floors. Okay? But what do we have? The economic model is completely overturned. And we're seeing a much different society that advances at a really rapid pace. And we're at the cutting edge still, and we still need to deal with all these things. So let's think progressively.
One of our goals initially was to come and say something so offensive we'd never be invited back.
So I do want to add a couple of things. I think you're right. I think that the world is changing rapidly, and I don't think the law is keeping up. If you go back and read some of the cases on mixed race marriages, there's some remarkably offensive language from 50 years ago. If you go back and read some of the 60 years ago.
Well, 40 years ago in Virginia in the 70s, I think.
Right. If you go back and read some of the early DV cases, they're amazing. They're remarkable. And this is short time stuff. So we're still working on trying to catch up with what people are doing.
We still have right now same-sex
Same-sex marriage.
Same-sex marriage is the new issue of that stuff.
Right. So I personally think that by the time we get the same-sex marriage thing all squared away, access to justice is the next big civil rights issue. You can have all the courthouses in the world, you can have all the stuff in the world you want. If you don't have access to justice, you're stuck. So I do think that the ideas of pushing things earlier into the process, by the time somebody's sat around for 6 months waiting for orders, it's too late. We need to move things earlier in the process, resolve things earlier.
And my final comment, before I say thank you all, but my final comment is, we've gotten a long way to change the language from pro pers to self-represented parents, which I think is great. Let's change the language from litigants to parents. I think that's a very helpful thing as well. I thank you all for incredible participation. If anybody wants this document that I've typed up, email me. It'll be sent to you as a PDF form. And it's 5 o'clock somewhere, as Jimmy Buffett would say. Have a great evening.
Thank you.